This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Atty General Rosenblum files lawsuit against U.S. Homeland Security, announces criminal investigation. This was posted July 17th. The Oregon Attorney General Ellen Rosenblum this evening will file a lawsuit in federal court against the United States Department of Homeland Security, Marshals Service, Customs and Border Protection, and Federal Protection Service, and their agents, alleging that they have engaged in unlawful law enforcement in violation of the civil rights of Oregonians by seizing and detaining them without probable cause. The lawsuit will be followed by a motion for a temporary restraining order regarding the forcible detainment of an Oregon resident, Mark Pettibone. If granted, the TRO would immediately stop federal authorities from unlawfully detaining Oregonians. Rosenblum's actions come in response to two disturbing incidents that occurred this week. Both involved federal authorities overstepping their powers and injuring or threatening peaceful protesters on the streets of downtown Portland. The first of these took place on July 12, 2020, when a peaceful protester was standing near the Marco Hatfield United States Courthouse. The protester was hit in the head with an impact weapon and suffered severe injuries. The second occurred July 16th, 2020, also in downtown Portland, when an unmarked minivan with undercover federal agents wearing generic green military fatigues forcibly detained Mark Pettibone, who was walking on a sidewalk. Pettibone was later held at the federal courthouse and eventually let go. The Oregon Department of Justice Criminal Justice Division has opened an investigation into the July 12th incident. It is joined in this criminal investigation by Multnomah County District Attorney Rod Underhill. Attorney General Rosenblum says, "I share the concerns of our state and local leaders and our Oregon U.S. senators and certain congressional representatives that the current escalation of fear and violence in downtown Portland is being driven by federal law enforcement tactics that are entirely unnecessary and out of character with the Oregon way. These tactics must stop. They not only make it impossible for people to assert their First Amendment rights to protest peacefully, they also create a more volatile solution on our streets. We are today asking the federal court to stop the federal police from secretly stopping and forcibly grabbing Oregonians off our streets. And we are announcing a state criminal investigation with the Multnomah County District Attorney into the incident resulting in serious injuries to a peaceful protester, apparently committed by a federal police officer in downtown Portland last week. The federal administration has chosen Portland to use their scare tactics to stop our residents from protesting police brutality and from supporting the Black Lives Matter movement. Every American should be repulsed when they see this happening. If this can happen here in Portland, it can happen anywhere." What the heck are federal law enforcement officers doing in Portland? Writes Steve Vladeck, a professor of law at the University of Texas School of Law. I'm not going to go over the videos or any of that. This is going to be more of a legal analysis thing, but let's just look at what questions Professor Steve asks, or Professor Vladeck asks, and then we're going to go over the lawsuit that was filed over the same thing. So he asks which agencies' officers are being utilized. He says it's the Department of Justice, the FBI, the ATF, the DEA, the Bureau of Prisons, and the U.S. Marshal Service. And it comes from a previous order from the Attorney General in June. So that's one. And then question two, which federal laws? So he says Portland is, the sovereignty of the state of Oregon. Like, there's no federal sovereignty over Portland or over Oregon. So they have to have some other basis. They have to have some federal law. So they don't have a federal law, so they might need to do it under a state law. But Oregon does authorize them under state law. Do they have to identify themselves? Well, that's not clear, says this professor, because it's federal law, and federal law doesn't have to have officers identify themselves. But it's state law, and state law does have officers identifying themselves. So which is it? And so is the Department of Homeland Security involved, and why? Well, maybe it could be. We are within 100 miles of the border. This border, this 100-mile border, that if you're within this 100-mile border, then you're subject to Customs and Border Protection. Will we learn to answer these questions? And the professor says, maybe. So just bookending this for you a little bit. When we go and read this and we're not entirely sure what the heck's going on, nobody is. This is new territory for a lot of attorneys, judges, and everything. And you'll see why, because this does not happen very often. So let's take a look at the Oregon Attorney General, Ellen Rosenblum's lawsuit against the Department of Homeland Security, Customs and Border Protection, the United States Marshals Service, and the Federal Protective Service. And this should hopefully give us some actual facts, maybe, at least from the Attorney General's side, some actual facts of what actually happened. You know, we saw video of people being arrested by a uniformed but unidentified federal police officers. Let's see what they actually have to say. On information and belief, federal law enforcement officers have been using unmarked vehicles to drive around downtown Portland, detain protesters, and place them into the officers' unmarked vehicles, removing them from public without either arresting them or stating a basis for an arrest, since at least Tuesday, July 14th. The identity of the officers is not known, nor is their agency affiliation, according to videos and reports that the officers in question wear military fatigues with patches simply reading police, with no other identifying information. In one widely reported incident in the early hours of Wednesday, July 15th, Mark Pettibone alleges that he was confronted by armed men dressed in camouflage who took him off the street, pushed him into a van, drove him through downtown until unloading him into a building which is believed to have been the Mark O. Hatfield United States Courthouse, which would be federal territory. So that's one of the few places in Portland that would be considered federal territory. Pettibone alleges that he was put into a cell and read his Miranda rights, so the right to remain silent, but was not told why he was arrested, nor was he provided with a lawyer. He alleges that he was then released without any paperwork, citation, or record of his arrest. U.S. Customs and Border Protection has been reported by the Washington Post to have taken responsibility for pulling Mr. Pettibone off the streets of Portland and detaining him. On information and belief, unidentified federal officers, including John Does 1 to 10, have likewise detained other citizens off the Portland streets without warning or explanation, without a warrant, and without providing any way to determine who is directing this action. There is no way of knowing, in the absence of those officers identifying themselves, whether only U.S. Customs and Border Protection is engaging in these actions. The Marshal Service and other Homeland Security agencies reportedly have been sent to Portland to respond to the protests against racial inequality. Oregonians have the right to walk through downtown Portland at night and in the early hours of the morning. Ordinarily, a person exercising his right to walk through the streets of Portland who is confronted by anonymous men in military-type fatigues and ordered into an unmarked van can reasonably assume that he is being kidnapped and is the victim of a crime. Defendants are injuring the occupants of Portland by taking away citizens' ability to determine whether they are being kidnapped by militia or other malfeasants dressed in paramilitary gear, such that they may engage in self-defense to the fullest extent permitted by law, or are being arrested such that resistance might amount to a crime. State law enforcement officers are not being consulted or coordinated with on these federal detentions and could expend unnecessary resources responding to reports of an abduction when federal agents snatch people walking through downtown Portland without explanation or identification. Defendants' tactics violate the rights of all people detained without a warrant or a basis for arrest and violate the state's sovereign interests in enforcing its laws and in protecting people within its borders from kidnap and false arrest without serving any legitimate federal law enforcement purpose. So, couple things to go over here. First, it's important to go over concepts of federalism. We do not live in a country where the federal government has unlimited power over the states. Again, we do not live in that country. The federal government has limited power over the states. Only powers granted to it by the Constitution and the amendments. That's it. Maybe, I guess, state law could consent to federal power over the state, similarly to the way any sovereign body can consent to a lawsuit against it. So Oregon can authorize the federal government to do certain things by law, but it looks like Oregon has only authorized the federal government to enforce state law. And state law does say that officers have to identify themselves. There's also something in the Fifth Amendment called the Due Process Clause. The Fifth and 14th Amendments to the U.S. Constitution contain a due process clause. The Due Process Clause deals with the administration of justice, which means the procedures of justice, and thus the Due Process Clause acts as a safeguard from the arbitrary denial of constitutionally guaranteed life, liberty, and property interests by the government outside the sanction of law. The Supreme Court of the United States interprets the clause broadly, concluding that these clauses provide three protections: procedural due process in civil and criminal proceedings. That means that you have the right to a meaningful legal process after notice of your charges. That notice must be actual notice. You must have a meaningful opportunity to respond. The court must give a reasoned decision. It can't be a kangaroo court where you just show up and the judge hits the gavel and says guilty. It has to be a meaningful process. You also have something called substantive due process, which is a interpretation of the Due Process Clause saying that you must have some sort of rights that come along with the due process, your procedural due process. So the Substantive Due Process Clause embraces those fundamental rights that are implicit in the concept of ordered liberty. Privacy, for example, is one of those fundamental rights which was recognized in Griswold v. Connecticut. It also embodies a prohibition against vague laws, and it is the vehicle for the incorporation of the Bill of Rights. That just means that the Bill of Rights applies to the states through the 14th Amendment and not just to the federal government. So back to our lawsuit. They are claiming a violation of First Amendment rights. So you have a right to peaceably assemble. Citizens peacefully gathering on the streets of Portland to protest racial inequality have the right to gather and express themselves under the First Amendment. Defendants' actions are undertaken with the intent of discouraging lawful protest and therefore constitute an illegal prior restraint on the First Amendment right of Oregonians to peacefully protest racial inequality. Citizens who are reasonably afraid of being picked up and shoved into unmarked vans, possibly by federal officers, possibly by individuals opposed to the protest, will feel compelled to stay away for their own personal safety and will therefore be unable to express themselves in a way they have a right to do. Second claim for relief is the violation of the Fourth and Fifth Amendment rights. The Fourth Amendment prohibits unreasonable searches and seizures, and in particular prohibits federal officers from seizing a person without a warrant or an exception to the warrant requirement. And the state of Oregon has enacted laws that make it a crime to detain a person without authority. Defendants did not have a warrant to seize Pettibone or other citizens who have been detained, and will continue to seize individuals off the street without a warrant in the absence of any injunction, and no exception to the warrant requirement justified or will justify those seizures. So in other words, without stating why they arrested Mark Pettibone, what did he do? So without a statement, it's a violation of the Fourth and Fifth Amendments if they don't have a reason. Defendant's conduct described above constitutes an unreasonable seizure of Pettibone, the person, and the other citizens who were and will be detained. The Fifth Amendment prohibits federal officers from depriving a person of life, liberty, or property without due process of law. Defendants did not afford and will not afford Pettibone and other citizens who were and will be detained due process of law. In other words, they picked him up, they held him, they dropped him off, and now he doesn't have any further court process to exonerate himself. Or was it Eighth Amendment right to confront your accuser? The third claim for relief looks like a civil rights claim. There is an actual case or controversy. Oregonian citizens are at risk of being kidnapped by militia or other civilian volunteers taking it onto themselves to pull peaceful protesters into their cars in a manner that resembles federal actions described above. And Oregon's own police agencies are therefore injured by roving federal officers confusing citizens about whether they are obligated to comply with armed men ordering them into unmarked vans. The Attorney General is entitled to a declaration that the acts at issue are unlawful and an injunction precluding defendants from continuing in them. They also accuse them of public nuisance because the acts constitute a public nuisance by unreasonably interfering with the general public's right to safety, public peace, public comfort, and public convenience. So that is Attorney General Ellen Rosenblum's lawsuit against, it looks like, the Department of Homeland Security, Customs and Border Protection, Marshals Service, and Federal Protection Services. And I hope the judge is able to order some kind of preliminary injunction preventing this, because this is unnecessary. If these people have committed crimes, then you don't need to not charge them with a crime and then let them go. If they haven't committed crimes, then you don't pick them up off the street. You don't arrest them, or you don't detain them, or you don't kidnap them. And if you did arrest them without probable cause or exception or suspicion, whatever the standard is in Oregon, then you kidnapped them and they deserve to sue you for kidnapping them. So let us know what you think in the comments below. On one hand, I hear people on one side of the fence who are completely against protesters having any free speech rights whatsoever. And it's really interesting to me because some of the very same people used to tell me that free speech was very important and you couldn't have a person force a cake maker to make a cake for a couple that they didn't want to make a cake for. And then the same people, you know, not everybody's the same, but definitely some of the exact same people, like I can name them, they're in my life. Some of the same people turn around and say that those protesters in Oregon have no First Amendment right to protest. And it's obviously not true. If the cake maker has First Amendment rights, so does the Oregonian protester. So there has to be a crime. Show us what the crime is that required that person to be arrested, charge them with the crime, take them through a trial or pleading guilty process because they committed the crime, and then show us that they're convicted. Instead, what you're doing sounds an awful lot like black sites and black ops and Secret Service and secret police and disappearing people off the streets because you don't like the fact that they're protesting you. That's what it sounds like. It sounds like you have a large ego, a small mind, and don't understand the Constitution that you swore an oath to uphold. Let us know what you think in the comments below. All right, that's our show, everyone. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel on YouTube, Twitch, and Floatplane. This is a community-supported channel. We would not exist without your financial support on a monthly basis on patreon.com/ljfrench and sponsors.com/law. Special thanks in the month of July to BU1 Simmons for supporting our channel. Thank you to our July $50 plus supporters, Nicely Done Defense, Joe Tyson, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Steven, Cute Grills in Your Area, Strawberry Puptart, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Gregory Conklin, Josh Baker, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, Hot Grills in Your Area, Ameknight, and Brandyn Abel. And thank you to the July $5 plus supporters who are in the description of the video below. I love you all. I really am thankful for all of your support. We really would not be able to do this without you. Have a good one. I'll see you hopefully next time from Luxembourg. Bye.